Committee.
That's us from public session. Okay, thank you. Members, the meeting is now open to the public. As usual, the committee is going to be recorded and broadcast throughout Parliament buildings and online. Anybody who's joining us in the public gallery is welcome, and you can use your mobile devices, but they should be in airplane mode and muted. Members, it's proposed that the oral evidence session with the Assembly's Research and Information Service on the potential financial implications of the Justice Bill, the session with the departmental officials on the legislative consent memorandum on the arbitration bill, and the session with departmental officials on the consultation responses to the PSNI injury on duty scheme will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Members, just a further reminder that obviously we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now, or indeed when the particular matter arises in the course of the meeting. Does anybody have anything they wish to declare at this stage?
An immediate family member who works in the court service.
Thanks, Deirdre. Likewise, as I do every week, I will declare that I have an immediate family member who works in the legal profession. Thank you. Item number 3 is draft minutes of the last meeting, which was on the 10th of October. These are at pages 21 to 29 of your pack. Are members content that those are a true and accurate reflection of that meeting?
Yeah, great.
That's grand, and I'll sign the minutes. Thank you. Agenda item 4 is matters arising. And there we had the informal meeting with the Association of British Insurers. The notes of that meeting are at pages 31 and 32 of the pack. Are members content to note the paper? So I was present at that, as was Justin and Doug, and from the Committee for the Economy. Obviously our clerk and so on was there, and for the Committee of the Economy, Diane was there, wasn't she? And their clerk as well. So. Agenda item 5 is the Justice Bill and the potential financial implications. Members, I would refer you to pages 33 to 72 of your meeting pack, which is the RAISE paper. So Aidan Stennett from RAISE is in attendance. Aidan, thank you very much for bringing your briefing to us today, and we're going to hand over to you shortly. Just to give you some indication as to where we are, some members have some questions once you finish your briefing, and obviously there could be things that are thrown up in the course of your briefing, but at this stage members have some questions around the costs, around biometrics, the Commissioner, children's bail, registered intermediaries, and some issues around the balance of costs to rights and duties. So we'll hit all of those, but we'll hand over to you for now, and then we'll take it from there.
Okay, thank you, Chair. So as you point out, Chair, I'm here today to talk to you about the costings in the Justice Bill, particularly those costings that are presented in the explanatory and financial memorandum. So this briefing and this presentation supplements your previous briefing by my colleague Judith on the policy implications of the bill. The purpose is to further support the committee's scrutiny of that bill, and throughout the paper you'll notice that I've raised some scrutiny points that are designed to help support the committee's scrutiny processes. So first of all, just to talk to you about what I'm going to cover today. So the themes for the day are the costs as outlined in the explanatory and financial memorandum. Then I'll talk a little bit about the budgetary context that the bill has been introduced in. I'll move on to talk about some of the potential costs of the public purse identified in the bill as it's been introduced. Because I'm going to throw a lot of information at you during this presentation, I'll just summarise at the end with a few key takeaways. Okay, so the financial effects of the bill as stated in the explanatory and financial memorandum. So the AFM includes just limited financial information. There are no concrete numbers in the AFM. It states simply that in terms of the financial effects, the bill as a whole will primarily be delivered within existing resources. It also states that some provisions will be subject to individual business cases, but doesn't indicate what provisions will be subject to such cases. Looking at the budgetary context, and I've tried to do this at 3 different levels. Starting off at the United Kingdom budgetary context, this remains uncertain since the change of government. There's going to be a budget next week, and that's going to be a key fiscal event that will provide clarity not only to the United Kingdom's budget going forward, but also Northern Ireland's spending envelope. Ahead of that budget, though, the Treasury has highlighted that difficult decisions will be necessary, and in the press this morning there was talk of £50 billion worth of tax and spending measures to come in that budget. At the same time, the spending review is ongoing, and that's going to be completed in spring 2025. The impact of that on public finances is obviously unclear at present. Moving down to a Northern Ireland budgetary context, the Minister for Finance has noted that there are increased demands on public resources and limited spending resources to meet those those demands on public services. And recently, the Department for Finance has published the Executive Agreed Budget Sustainability Plan, and that highlights the need for balanced budgets and the sustainable use of resources. So then focusing in on the Department of Justice itself, in September 2024, the Department noted that it was subject to 351.1 million in spending pressures, and that extremely difficult decisions on prioritisation and service provision were necessary. They also highlighted the action that they have taken or are considering taking to address those spending pressures, and that includes things like staff-related actions and scaling back on some projects and services. And the DOJ also in September 2024 noted that the budget pressures are having or could have significant impacts on PSNI delivering services to community, and they highlighted at the same time things like a decline in planned officer numbers from 7,100 in 21-22 to 6,358 in March of this year, and they highlighted pressures on 999, reduced neighbourhood policing teams and reduced presence on roads, less detectives available to investigate crimes, and potential for station closures and restrictions. So within that context, we'll move on to look at the provisions of the bill and their potential financial implications. So the first part of the bill, members will be aware, focuses on DNA and biometric information, and there's two main parts of this. The biometric retention period, regime, I guess. So the bill as introduced proposes a 70-50-25 model where the length of retention is determined by things like the nature of the offence, the outcome, and the age of the individual. Raise contacted the PSNI to get some views on the potential costs of this, and the PSNI noted in their response that they spent previously in 17-18 2.1 million on IT for the biometric provisions included in the Criminal Justice Act back in 2013, but were not enacted. They also noted that their 2024 10-year capital plan contains a 0.5 million inescapable bid for biometric software development in the 26-27 financial year. Commenting on the new proposals, the PSNI said that these were more complex than those in the Criminal Justice Act 2013, and as a result the cost to the organisation would be commensurate with the complexity of the final requirement. The PSNI noted that at present it's extremely difficult to calculate the projected costs, and have stated that they won't be in a position to commence work on software development until the bill receives royal assent and any consultation is completed on the related secondary regulations. And there are three areas where secondary regulations have been mooted in the bill. The first regards the power to make further transitional savings or provisions. The second is the review of long-term retained data, And the third area is in relation to persons charged with a qualifying offence. And the secondary legislation raises a couple of questions, I suppose. First of all, when is that going to be introduced to the Assembly? And whether the department is planning to do any consultation or cost-benefit analysis on that regulation before it is introduced. Okay, so the second big area in the part one is the biometric commissioner. Again, Ray's contacted the department to ask for some information on this. The department stated that it's progressing work to assess the potential costs, but as this was ongoing, it would not be appropriate to share at this stage. Similar organisations operate in GB. In England and Wales, there's the Biometric Surveillance Camera Commissioner. That was established in 2021 and had an annual budget of just under £600,000. That commission employed 7 staff out of a complement of 9, and these figures relate to the 23-24 financial year. The Scottish Biometrics Commissioner had a budget of £415,000 in 2022-23, and that was staffed by the Commissioner and 3 full-time members of staff. In the first year, the Scottish Commissioner's costs were £278,000, and that covered both the setup and running costs of that organisation. Okay, moving on to part 2, which concerns bail and custody provisions for children. The department, again, we contacted the department about this. The department have stated that the new custody and bail proposals for children have been introduced to ensure compliance with international instruments rather than with a view to saving money. That said, the department hopes that they will reduce pre-trial detention. The figures from the Youth Justice Agency's annual reports show that the average cost of custody per young person is rising based on one of the methodologies that they gathered figures on. So there's 2 methodologies, which I've called the maximum number of places, which is the total operating expenditure divided by the maximum number of spaces available. And the second is resourced places, and that's the total operating expenditure divided by the number of resource places available based on staffing levels and resources available for service delivery. And it's this second one where there has been a rise in the annual cost of custody per young person. And the agency has commented that the reasons for this rise include staff costs. And finally on this, the DOJ has noted that it's difficulty in calculating the cost of keeping children in custody where bail has been granted but no suitable accommodation has been secured, and they state that is given that a high proportion of the operating costs of the Juvenile Justice Centre are fixed, it is not possible to accurately assess the cost of keeping children in the facility for an additional number of days post-granting of bail due to the lack of appropriate alternative accommodation. Part 3 of the bill concerns the use of live links, and if enacted, the bill would extend the use of live links to enable remote interviewing by police officers and for seeking authorisations of pre-charge detention. So on this, the DOJ have stated that they do not consider there to be any additional cost for this, and that it may in fact result in efficiencies due to things like reduced travel and escort costs. At the same time, this hasn't been quantified, and that opinion was supported by respondents to the Live Links consultation that took place back in June 2020. And then part 4 of the bill, it contains a range of provisions under the heading Administration of Justice, and the paper looked at 4 of those that could have potential public purse implications if enacted. So clause 26 is about extending the use of registered intermediaries to the Court of Appeal. In the response to us, the department noted that this currently happens when approved by the judiciary, and that the bill proposes a statutory basis for this. The department expects this to result in 2 or 3 additional cases per year at a cost of £300 to £400 per case. Clauses 27 and 28 amend the role of if introduced or if enacted, amend the role of the tax ambassador in determining the payment for legal aid and allow the department to determine the amount it pays. The DOJ states that the provision in of itself will not save money. They've also stated that they are yet to determine a fee structure and will not be able to assess any financial savings until that is carried out. Clause 29 will extend the scope of the independent reviewer's criminal records automatic review powers. The DOJ has noted that such reviews are already being carried out by the independent reviewer and have been since March 2020. They have added that the independent reviewer has done so without the need for additional resources and therefore do not envisage any additional costs. And then clause 30 allows the department to extend court security provision through secondary legislation, and the DOJ has stated that it does not foresee any costs arising from those provisions. Again, as with the biometric secondary legislation, there are some unknowns here when it will be introduced and what sort of pre-introduction costing and consultation will take place. Okay, just to sum up, some key takeaways. The explanatory financial memorandum has limited financial information and states that the budget provisions will be met by the bill's provisions will be met by existing budgets. The bill has been introduced at a time of budgetary pressure, unknowns, and a renewed focus on sustainability within Northern Ireland. The PSNI has noted that it expects costs to arise from biometric provisions if enacted, but it is not currently in a position to provide an estimate of those costs. The biometric commissioner provision is likely to introduce costs, both set up and operational. Similar organisations in Great Britain have annual budgets of between 400,000 and 600,000 per year. The department is carrying out cost assessment on this, but is unable to share at this point. The LiveLinks proposals may improve efficiency, but the impact of this has been unquantified. And the DOJ suggests that the administration and justice provisions examined in the paper will have a limited or nil additional cost to the public purse. And then there's the issue of secondary legislation, particularly in biometrics and cost security. This introduces unknowns, and the key questions are, as I've said a couple of times now, when will they be introduced and what cost benefit or consultation will take place. So that's me, Chair. I'm happy to take any questions you have and hopefully I can answer them.
And that's great, thank you very much. I think you're in a very difficult position because you're here to provide us with a financial briefing when actually you haven't been given any information. So it's been really difficult for you, but thank you for highlighting some of the questions that you have. I'm going to open the floor to members. First of all, if we can, members, just a reminder that whilst we're going to ask Aidan the questions, some of these questions could end up just having been posed to the department. And obviously Aidan's here representing Assembly Research and not the department. So we'll work our way through it and see what we can get to anyway. So the first subject we're going to look at is biometrics, and I know that Stephen has stuff around this, and so does Deirdre. Go ahead, Stephen.
Thank you, Chair. Thanks, Aidan, for your presentation. I appreciate you have a lot of work on your hands and very detailed indeed. Just around on the packet talks about the PSNI stated or noted that they have resourcing issues within their IT department. I'd be keen to hear a bit more about that. If you have any more information on that,
I don't. That's as much as they've said. They were laying out in the response. They laid out a range of issues that were causing them difficulties in providing an assessment of the costs, and that was one of the ones they've listed. It may be something that you could go back to the PSNI on to get more information.
Yeah, okay. And just then in terms of obviously the budget issues, that's a major concern, linking in then with the Commissioner. We've seen the figures around Scotland, 415 and GB, 400 to 500,000. In your opinion, is there any assessment of how realistic it is that the department will have the resources to meet this need?
Yeah, that's the questions I was asking throughout the paper. With the scrutiny points, I'm not sure the department haven't completed their assessment of the costs, so it's a big unknown now until they're in a position to share that.
Yeah, And then just finally, going back to the 2.1 million the PSNI had spent in 17-18 on the IT technology. And then obviously it's a lot more complex, the proposed scheme, from it was in 2013 through the Criminal Justice Act. Is there any more detail available from your work to date?
Just that the PSNI have pointed out that 2.1 million didn't include internal PSNI staff costs, such as the reassignment of staff within the organisation, the costs to the criminal justice organisations involved in the development of the software, and costs to national bodies such as the Police National Computer and the Forensic Information Database. So what that is suggesting is the 2.1 million on IT is likely just to be a small proportion of what they paid at the time. And they have said that due to the complexity of what is being proposed in their view, the software cost will be commensurate to that.
Yeah, 7 years on from the 17-18 figure, yeah. Okay, thanks, Chair. Thanks, Aidan, in the meantime.
Thank you, Stephen. Deirdre?
Yeah, no, thanks very much for your presentation. I suppose the scrutiny questions then for the department are going to be really useful in the report. It was just on the issue in the biometrics around the additional regs that would come. And I have obviously a concern in terms of particularly the review process. And there's nothing contained within that then, sure there's not, by way of additional financial information. Because my concern would be when you look at, for example, the Ombudsman, a way to stop some of that worker review is to constrain the budget. And a concern that could happen here if it's not going to come then until regulations. So,
yeah, there's nothing in the
yeah.
AFM that talks to that, and I don't believe, or I'd have to go back to it, that the department spoke to that in their
and
response.
the consultation didn't include any costs impacts either. Sure, it didn't around the biometrics, but
pardon me.
no, you're okay.
So I think just simply that respondents were concerned about resources in particular for the review function and the Biometrics Commissioner.
Yeah, you see in terms of because we've done some benchmarking with the Commissioner, is there a review function in the other jurisdictions that we could get an idea of then in terms of cost analysis that we could try and compare in the absence of any costs coming yet from the department?
I'm not 100% sure, but it's something I could look at for you. Yeah, certainly.
No, I think that would be good. Thank you. You answered my question already on the setup costs because I was going to ask in terms of those initial costs. But where you said, sorry, the increase in costs, I think it was in Scotland. So there was quite a jump. But is that was mainly staff costs, or were there other?
Yeah, I believe that's the difference between running for a part year and a full year.
Okay. And the other bit, I suppose, I mean, it is the balance here. We could look at this purely through a cost analysis, and it is important. I mean, I think part of the issue is we don't have all the financial information. We were told that we were going to get more, and we haven't received it yet, so I do think there will be queries that we're going to have to put into the department, but it's balancing that against the rights, and this is the right thing to do on the back of legal judgments that have been taken as well. So I suppose that it is that double-edged sword that we're kind of trying to follow here, that it is the right thing to do. It's a better system for children and young people, and particularly around the DNA retention. But for me, with so much, I suppose, regulation provisions, will it actually be done, or will the costs be used as a way of not completing those or implementing them further down the line? So no, I would be keen in that review process around the biometrics if we could look at some benchmark in other areas, if there is similar provisions that exist there as well. I think that would be good. Thank you.
Does anybody else have anything else on the biometrics or the Commissioner? I do. Aidan, from what you have read, it's the costs around the Commissioner in Scotland, 330, in the year 2022-23 financial year, 332,000 for the Commissioner and 3 full-time equivalents. In the course of your research, did you have a breakdown of that?
That should be in their annual report and accounts. I can find that for you if it is there. Yeah.
That would be helpful, and if not, we'll ask the department to get it. But I mean, I think those are quite astonishing costs, to be honest. Also, within your report, the PSNI has specified that they have cooperation of other bodies who may seek full cost recovery from the PSNI. Did they elaborate with you on that, Aidan?
No, that's just...
So that may be something that we need to take up with the PSNI, what's going on around that then. That's fair enough, thank you. We'll make a note of that and take that forward. Right, if nobody else has anything on biometrics, I'm going to move on to Morris, who's got questions around children's bail.
Thanks very much for your presentation, Aidan. Very insightful. My questions around as John said, the Chair said, children's custody and bail, and provisions aimed at reducing that pre-detention operation. But it says here, according to the information I've gleaned out of this here, that it's around 387,000 per young person, but it doesn't say how it arrives at that cost. And then that's a very, very hefty cost per young person. But what does it entail?
That one is the cost. So as I said in the presentation, there's two ways that Youth Justice Agency calculate the cost, and that one is the total operating expenditure divided by the number of resourced places available. And resource places is based on staffing levels and the resources available for service delivery. That's how it's set out in the methodology, and the reason for the increase or the movement in it, the Youth Justice Agency says, is it reflects rising staff costs within the agency and higher depreciation costs for the replacement of capital works at Woodlands Juvenile Justice Centre. So one of the scrutiny points I suggested there is that the committee may wish to ask the Justice Agency which is its preferred methodology for measuring this, but I think it's another one could be, explain exactly what this entails, what the operating costs entail, and to break that figure down a bit more.
Would make it more understandable because it's a big cost. And the other one is around the registered intermediaries, the expansion of the registered intermediaries to appeal cases. And you have said that they don't expect any more than 2 at a cost of £300 to £400 per case. How can you be sure that that would be as low a number as an additional 2 per year?
I'm literally just quoting the department's numbers there. I think I'm taking them at face value.
We need to follow that up with the department.
Yep.
We'll follow your previous query up with the department too, I think.
I think that'll be.
Morris.
Thanks, Aidan.
Does anybody else have anything on children's bail or intermediaries? No? Okay, Ciara, over to you on legal aid.
Okay, just one really specific question. Just in your review with the department on legal aid, was there any indication from the department how they believe they are going to be able to set the fees, set the rates, given the fact that, and I know obviously myself and Stuart and the All Party Group Access to Justice meeting with the Law Society and the Bar this week, the complexity over the last 15-20 years in cases in themselves regarding technology that has to be utilised, the complexity and the vulnerability of individuals that they work with, it's become quite complex. The actual fee itself has remained quite static over many years. So I'm interested to know what ongoing work, or is there other models of good practice and how the department sees is going to be able to move forward in setting a rate?
I don't have any more detail on
No.
that beyond the fact that the department are seeking to determine a fee structure. They'll take into account value of money, and because of that, they're not able, because it's yet to be determined. They're not able to comment on whether there'll be any financial savings through it. But really, the sort of the policy side of it, and really,
There's nothing seems to be there at the minute.
well, I focused basically on the financial
Side of
of here. I wasn't.
That's something we could go back on.
Yes, I think we're going to end up coming back to it anyway, Ciara, because the issue with it is that I suppose part of the powers the department has taken are to set rates. They're also going to determine on a case-by-case basis what's paid and all the rest. So there are issues around consistency. There are issues about work that's actually done, and then I think there are question marks too about where that leaves the taxing master and the role of the taxing master. So honestly, I think this was the financial aspects. I think we have further financial issues to tease out with the department, but some of those issues and the general principles will need to be teasing out as we further scrutinise the bill and get into that section of the bill.
Well, that's
You know.
fine. No, thank you.
That's great, Ciara, thank you. I don't know if, does anybody have anything else that's arising now because of what they've heard?
Just sort of one general question.
Stuart.
Otherwise, I didn't have any specific questions on the topic areas. Given that most, if not all, legislation will have a financial implication, and the fact that this legislation in great part comes about because of either court judgments or directions or just a modernising desire to deliver the policy intent, where does that sit in terms of, is this a small, medium, modest, or extremely large financial implication to implement this bill?
I don't know if I can really say. There isn't a great deal of information there to quantifies it.
How does it sit with other legislation and the costs?
This is the problem, Stuart. We don't have the costs, because on every question that's been asked of the department with regard to the financial implications and how things are going to be funded, the department has come back in the course of the paper under every section and said, we're not in a position to share this. We're still working things out. We're not in a position to share it. The PSNI, who presumably have indicated what they spent on the previous bill, have said, we actually can't cost any of this until we know what has been passed. So I think Aidan was in a very difficult position. I think the committee is in a very difficult position.
The department's in a difficult situation. The department is probably also in a very difficult situation, given that they have judicial decisions imposed on them to make changes, and they too have to be able to work this out. And I guess it's a chicken and egg. Until you have the legislation, you don't know how much it's going to cost, but you've got to work out some sort of ballpark figure that will deliver it.
Well, they do, but what they are saying is that they are working through some of this, but they're not in a position to share it. Now, there are a couple of points. The department has indicated that it will, as Aidan outlined in the start of his briefing, the department has outlined that a lot of this is going to be paid for from existing resources, and where it isn't, they're going to produce business cases. What they haven't told us is, as Aidan pointed out again, okay, which aspects of this are going to be business case, and which is now the other problem that we face is on the other side of this is the department is telling us that it doesn't have the finances to fulfil its statutory obligations already, and now it's just saying, well, this can be paid for from the existing resources. So I think that we're going to have to tease more out about this. More than that, I'm certain, I'm fairly certain it was either during question time or in the course of the second stage debate that the minister indicated in the House that the department was going to send us, was sending us or had sent a detailed financial outline about how they envisaged this bill would be paid for, what the costings would be and so on. Now, could I check, because it's clear Aidan hasn't received that paper yet, have the officials received that paper yet? No, I mean, so what I'm trying to establish is, whenever the minister refers to that paper, is she referring to a response that was prepared for Aidan that essentially says, well, we can't share it, or is there something different that's coming? And I think that we need to, I think we need to clarify this, because at this point, what we're being given is, well, we're working on that, so we can't share it, or we don't have any notion at this stage how things are going to be paid for. And and the purpose of this and the purpose of Aidan's work was to give us some clarity on that, but I'm not clear at this stage that we're actually any further on. Despite Aidan, that is zero reflection on you. I mean, if you're not being given the information, I think what you have produced is really useful in terms of questions. And I mean, the point was made, I think, in second stage order, the permanent secretary. If you can't fulfil your existing statutory obligations, how do you intend to finance things that you're saying can come from existing resources? So these are issues that we're going to have to look into as we progress, but at this stage I suppose we're still scoping, but it's difficult at this stage, when we're looking at the financials, to not have anything.
I think it would be good to ask the department, and at least for a timeline if it's not ready, so that we can consider it. I mean, a caveat that we'll have to balance this against court judgments and people's rights, so it is a fine balance, but obviously as we're scrutinising, looking at the finances as a part of it in the context that has already been given out in terms of where budgets are. So I think just to clarify with the department, if we can go back and just ask for that, or for a timeline as to when, and that will allow us in terms of our forward work programme as we're scrutinising the bill, to look at these issues.
Yeah, but the starting point is the Minister had referenced a paper.
Yeah.
Is that a different paper to the one that was sent to Raise?
Already on that.
Where is it? And then timeframes around when they will be able to share with us information.
Yeah, Chair, was my reading of that it was the information that had been provided to Aidan, but we can double check.
Because my understanding of that kind of the Minister's remarks, which I think were made in faith, was that there was a detailed report coming. But if the detailed report is we can't share it, I'm not sure that leaves the committee in a good place. So let's pursue that a wee bit and see what we can tease out. And I appreciate some of this is chicken and egg, but if they're working on it, I mean, at some stage we're going to have to see something. We're going to need to understand what the impact this is going to have is on the departmental budgets. So does anybody have anything else for Aidan, or is he free? Aidan, thank you so much. That's great. Thank you. In terms of going forward, are there any questions from Aidan's paper, any further questions that we want to send on? Do we want to send all of them on? How do we wish to proceed with that?
And send them all, and everybody.
A general correspondence to the department to remind them of their indication of the financial implications of the bill, and that we're effectively still awaiting that.
Thank you. Aidan, thanks very much.
Thank you.
Okay. So do you guys have all you need then with regard to that? Yes. All right, thank you. Agenda item 6 then is the arbitration bill, LCM. And we're about to receive oral evidence from departmental officials. Could I ask members to turn to pages 73 to 131 of their meeting packs for the relevant papers? Members, as you'll see, we have officials from DOJ in attendance with regard to this LCM. You'll remember that the arbitration bill was introduced in the House of Lords on the 18th of July this year. And the committee considered a previous arbitration bill which fell when Parliament was dissolved for the UK general election last May. So I'd like to welcome Andrew Dawson, the Deputy Director of Civil Justice and Judicial Policy Division, Jane Maguire, Head of the Civil and Family Courts Branch, and Andrew Robinson, also from the Civil and Family Courts Branch. Andrew and I know each other from previous lives. It's good to have you with us today, folks. Thank you for taking the time. I am going to invite you to give your presentation, and then doubtless we'll have some questions for you. Could I ask, just in the course of your presentation, Andrea, I appreciate it's kind of in your paper, but for the record, and because we're being hand-sorted, I'd be really grateful if you would indicate essentially what the differences are between the bill that's in front of Parliament now and the changes that were made in this one compared to what was in front of them in the one that failed. Thank you.
Thank you very much indeed for the opportunity to discuss this. As you mentioned, the bill was introduced in the House of Lords in July, and it's scheduled for report stage in the Lords next week. As you mentioned again, this is the second time the bill has been introduced in Parliament. It was first introduced last year under the previous government, and it didn't complete its passage due to the dissolution of Parliament before the general election. The bill amends the Arbitration Act 1996 to give effect to recommendations from the Law Commission of England and Wales. And as the 1996 Act also governs arbitration in this jurisdiction, the bill extends to Northern Ireland. In terms of putting on the record the differences between the bill from the last session and this, Andrew and Jane will speak to that shortly, but as I understand it, they are extremely similar in scope and nature, so, but they'll be able to talk better to that. By way of background, just generally, in March 2021, the Ministry of Justice asked the Law Commission of England and Wales to review the 1996 Act to ensure that it remained fit for purpose and continues to promote the UK's position as an international leader in the field of arbitration. It's estimated that the sector is worth at least 2.5 billion to the UK economy each year. We don't have a breakdown as to what that would mean for Northern Ireland specifically. The Law Commission began its review then in January 2022 and carried out 2 public consultations, one in September 22 and a further one in March 23. As part of its consideration, the Commission engaged with a number of key stakeholders in this jurisdiction and also received a Northern Ireland perspective from Mr Justice Schofield, the chair of the NI Law Commission. The England and Wales Law Commission's final report, together with a draft bill, was published in September 23. The then government agreed to implement all of the Commission's recommendations. The Law Commission's report reflected the view of stakeholders and practitioners that the 1996 Act generally works well and that substantial reform is not required. The bill therefore makes targeted reforms. The law regulating arbitration is a specialised area, and therefore the provisions in the bill are fairly technical and are in large part to address and provide greater clarity on matters arising from case law and practice. We have provided the clause-by-clause breakdown in your briefing, but in summary, the key aims and initiatives are to clarify the law that governs the arbitration process for international arbitration agreements, codify the duty on arbitrators to disclose potential conflicts of interest, and strengthen arbitrator immunity to ensure the impartiality of arbitrators, to enable arbitrators to dispose summarily of issues with no real prospect of success, and to strengthen court orders in support of arbitration proceedings. It's the view of this department that there are no issues specific to Northern Ireland which would require a different approach to that in England and Wales. If the bill did not extend to Northern Ireland, it would mean that arbitration here would be governed by slightly different procedures and that parties to arbitration would not have the same benefits of the improved and updated legal framework. So that's just a very brief outline of the bill. I would want to take a minute just to discuss process of this particular piece of business, if I could. In relation to the legislative consent process, the bill, as we've discussed, was first introduced in November 23 when the Assembly wasn't sitting. And by the time the institutions were restored in February 24, the first iteration of the bill had already completed several parliamentary stages. Unfortunately, we have not been able to engage with you until now, really, in respect of the current bill. It was reintroduced on the 18th of July, when the Assembly was in summer recess. But even after that, there was an issue that needed to be sorted out between ourselves and the Department for the Economy. There was a potential issue, or I suppose it turned out not to be an issue. It was a question at the time which has been answered in relation to the application of the 1996 Act to the Labour Relations Agency's employment arbitration scheme. DFE needed to consider the implications of the bill for that scheme. Pleased to say that DFE's concluded that the bill will have minimal impact on the LRA scheme and accordingly is content for the legislative consent process to be taken forward. Unfortunately, that issue took some time to resolve, meaning that our timetable is as ever, particularly challenging. The MOJ has, however, helpfully agreed to extend the deadline for consent to the final amending stage in the House of Commons, which slightly unusually is the second House to consider this particular bill, so that buys us some more time. We think obtaining legislative consent within that timescale is achievable, but the timescales are tight. We plan, or certainly hope, that the Executive will consider the matter at its meeting on the 7th of November, and subject to Executive approval, the legislative consent motion could be laid, and we will of course assist you and committee members in any way we can with scrutiny. Unfortunately, the bill timetabling is not within our control, but therefore for comfort we think it's probably preferable to obtain the Assembly's legislative consent prior to the Christmas recess, if at all possible. This is challenging, we think achievable, and it's really helpful, and we're very grateful to you today for adding us to your agenda. And with that, that's my introductory remarks concluded, and happy to answer any questions.
Thank you, Andrew. I don't know whether Andrew or Jane wants to comment about the specific differences between this bill and the previous one.
The differences aren't really that great. I think the main one really picks up on an amendment that was made to the original bill in the House of Lords, and it relates to Clause 1 of the bill, which deals with the law that's applicable to arbitration agreements. So what the bill does is replace the common law position with a new statutory rule to provide that the law governing the arbitration agreement, which is distinct from the law which will govern the contract between the parties, which is the subject of the arbitration, will be the law of the seat where the arbitration is taking place, unless the parties have expressly agreed otherwise. And just the bill then, as reintroduced, makes clear that that particular provision won't apply to arbitration agreements which are derived from standing offers to arbitrate, which may be contained in treaties and legislation relating to state foreign investment. So, because those are usually governed by international law, so it was agreed that that particular provision wouldn't apply. So it's very technical matter, and otherwise it's really just to correct I think a minor drafting error that had been picked up in relation to the 1996 Act, an incorrect consequential amendment that it had made, but that's really just a very minor and technical point.
That's it. Jane, just those international issues and
that's it. Yeah.
Okay, thank you. Deirdre, you wanted to come on this?
Yeah, no, thank you. I know it's technical and I don't understand so if I suppose the codifying bit around, I mean, I can see the importance of the duty in terms of conflicts of interest. That's very important. So is that the existing duty that you're looking to just strengthen and codify, or is there changes to what's already there now at the moment?
That's like close to your referring to there, yes. So that will codify the common law position. So the position is set out by the Supreme Court that arbitrators have a continuing duty to disclose any circumstances which might reasonably give rise to doubts about their impartiality, and that duty is based on what an arbitrator ought reasonably to have known. I think there was some case law had left unresolved the question of whether or not that duty was based on actual knowledge. So this new statutory provision will clarify, yes, that it's what they ought reasonably to be aware of.
And the other wee bit was just around the introducing the provisions for arbiters to dismiss legal claims on the lack of merit. Is there a review mechanism or process if that's disputed? Are you aware of? It's saying around introducing provisions for arbiters.
It's clause 7. There's an express power then arbitrators can make an award on a summary basis, but it's not necessarily mandatory. So parties can agree to disapply that in the original contract. And the amendment then to the 1996 Act also outlines that arbitrators can only exercise this power upon an application from one of the parties. So an arbitrator shouldn't just be able to do
Yes.
that off their own bat. So it would be one of the parties that would have to apply for that. There's not a specific procedure around that. It's very much a case-by-case basis as to how an
There's a
arbitrator...
a clear framework in which the arbiter has to work within in terms of enacting, I suppose, that provision.
Yeah, well, different arbitration institutions would have their own
Yeah.
procedures around that, so it would very much, I suppose, depend on which institution, if you go down the institutional arbitration rate, to be able to deal with that matter. But most of those institutions will have rules around that. I think the Law Commission didn't want to overly prescribe exactly how that procedure would work. It allows for a bit more flexibility than you would get, say, if you're going through litigation instead.
Okay. And my last wee one, sorry, was just around, I know there's no massive changes between the last. Is there likely to be anything between now and moving through executive agreement and that, any other kind of big amendments or anything that you think would change the scope of what's in front of us?
For our money in Northern Ireland, I wouldn't have expected there to be any further changes here. We'll obviously be watching carefully what happens as the bill progresses through
I mean, in
Westminster.
terms of it progressing through, is there anything that's
I would
alarms at the moment? Or no?
It's hard to say, but
Yeah.
I would say unlikely given the nature of the technical nature of the bill. But we'll be keeping a careful eye on it, and if there are any major developments, we'll keep you posted.
Okay.
It's had two good airings now through the House of Lords, and that was quite the technical process. So I don't think
Hopefully gives you
MOJ
good
are
sense,
expecting
yeah,
any more
of
at this stage. But
There was wide support for the bill,
Yeah.
so...
Okay. No, that's grand. Thank you.
Stuart?
I've had an interest to declare in these circumstances, given that in a former career I was the arbitration secretary in the Labour Relations Agency, so I will declare that as an interest.
Thank
You
you.
could have told us all about it.
yeah, you should be on this side of the desk, I think. Yeah.
Does anybody have anything else?
Just a final question on that. Obviously, you mentioned the Labour Relations Agency. Who are or where are the arbitrators? What organisations currently provide that service? What's the scale? What's the size? You probably could
I can
answer
tell
it,
you.
but I'm just going to pass it over to you officials.
I'll make a start anyway. We understand arbitrators, they are typically experienced professionals that are chosen for the role depending on the subject matter at the core of the dispute. They're not required to be legally qualified, but I think a lot of them are lawyers. They may be solicitors, barristers, retired judges. They can also be specialists in areas like construction or engineering, so chartered engineers. There is specific training and accreditation in arbitration. There's the Chartered Institute of Arbitrators, and that offers the designation of Chartered Arbitrator to qualified individuals. I also understand further to that arbitration agreements or clauses in the contract between parties can stipulate specific qualifications or experience for an arbitrator or a panel of arbitrators. They can also choose to select arbitrators from a panel maintained by various arbitration institutions. So that could be the London Court of International Arbitration, the Chartered Institute as mentioned, or the International Chamber of Commerce as well. So mostly locally lawyers, but don't have to be lawyers. And there's quite a range from which
Do we
they
know
draw.
what the number and scale is here in the north in comparison to GB and down south?
We don't. There's no real official statistics kept on that. Unfortunately, we don't know the extent of it, but I suspect it'll be a growing business as well, because this is a form of alternative dispute resolution. That's very much the road which I think parties in a dispute are being encouraged to go down. So, whilst I don't know the number, I think it will probably grow.
I think it's kind of... it's
For
very
information
sorry.
to that- Sorry, just for information to that, those arbitrators that fall under the responsibility of the Labour Relations Agency will be named and identified in the annual report of the Labour Relations Agency. There are other organisations in Northern Ireland that the legislation applies to, but you will have to gather that information elsewhere.
Yes.
And it's not just lawyers, there are trade union officials and a range of other people as well who qualify.
Engineers, like it's particularly used in relation to sort of commercial contracts, construction, so quite highly specialised areas, so it's those sort of areas where it'd be typically used.
I'm assuming there was an extensive consultation originally with all the whole range of stakeholders within construction, labour relations, etc., etc.
The review that was carried out by the Law Commission in England and Wales, which is where the bill came from, carried out. I think they had two consultation phases. They had a large number of responses to those, so there has been extensive engagement with the sector, and including some with sort of key stakeholders in Northern Ireland, both on behalf of the Law Commission and then through the Mr. Justice Schofield, who's the chair of the Law Commission in Northern Ireland.
Okay, members? Yep. Thank you. I suppose just a couple of points on that. I don't think, bearing in mind what Jane has outlined in terms of the distinctions between the last bill and this one, I don't think it's necessary for us to go back out to the Law Society and the FSB, who had consulted with us previously on this issue. I don't think we need to go back out, bearing in mind the technical nature of the change. So I've got a couple of questions then for the committee. So are members content to note the department's briefing and content for the LCM on the arbitration bill to be led for the Assembly as soon as possible? Yep. Thank you. Also, members, are you content to forward the briefing to the Committee for Finance and the Committee for the Economy, as a number of clauses in the bill touch on their responsibilities? Yes. That's great, thank you very much. Folks, could I thank you very much for taking the time to come to us today? That's greatly appreciated, thank you.
Thank you.
It's lovely when they're uncontroversial, isn't it? Thank you. Members, could I ask you to turn to agenda item 7, which is injury on duty and the consultation response. We anticipate oral evidence from the department. Could I ask you to turn to pages 132 to 203 in your pack? The officials here.
They're outside.
Use one topic.
Advised that we were running slightly, works advised that we were running slightly over, so.
Although we're not too far over now. Just clarify then, does anybody have anything? I have stuff on injury on duty, Morris, you have stuff. Does anybody else have anything?
Timeline, Chair. Just to give that time.
Yep.
Both the online.
Have they?
Yeah.
We're still going.
Yeah, we're still going.
At least I don't have to keep an eye out for hands with them.
I'll let you know if they do.
Hello everybody, you're very welcome, thank you. Thanks, Chair. Members, here we have officials from the DOJ. Again? Yes. With regard to the PSNI injury on duty scheme consultation responses and way forward document. I'd like to welcome Lynn Curran, the acting deputy, excuse me, it's easy for me to say, the acting deputy director of the Policing Policy and Strategy Division, Therese Murphy from Policing and HR Pensions Division, and Alan Crone from the Police Pensions and HR Policy Branch. Folks, I'll hand over to you, and then a couple of us have some questions around this, so we'll take those. Mostly it's around time frames and so on, but we'll hand over to you to give us your briefing. Thank you.
Thanks, Chair, appreciate it. You've obviously all been introduced to us, so I'll not go through that again. We welcome the opportunity to present to the Department's response to its consultation on the proposed changes to the Police Service Northern Ireland Injury and Duty Award Scheme. As requested by the committee, I'm also happy to present an analysis of correspondence received concerning the NIAO report and to offer an assessment in relation to the impact the allegations may have on the IOD consultation. I think it would be helpful at the outset if I reiterated the differences again between the ill health retirement pension and an injury and duty award, as I believe this issue still causes some confusion among some people. I also want to make it clear that the focus of the consultation that we're going to talk about later was in relation to the IOD scheme and was not in any way related to the ill health retirement pensions. So the rules surrounding ill health retirement are set out very clearly in the 2015 Police Pension Scheme. A serving officer may seek to or be required to ill health retire due to any illness or disability, for example, multiple sclerosis, cancer, or anything like that. This decision is not dependent upon whether an officer has been injured on duty. And as you know, retirement pensions are taxable. A determination by the board to permit ill health retirement is predicated on a number of considerations which are set out in statute. An injury and duty award is made to a person who ceases or has ceased to be a police officer. The purpose of an injury and duty award is to reflect any loss of earnings suffered due to injury received whilst on duty and to make sure the officer receives a guaranteed minimum income in the future. This is a tax-free benefit which is paid to officers for loss of earnings incurred due to their injury and duty. PSNI officers do not contribute to this benefit as it is wholly funded by the PSNI. As outlined previously, an ill health retirement pension and an injury and duty award are two distinct, mutually exclusive, standalone schemes governed by two separate legislative sets of regulations. The process for both is set out clearly in the process maps that we provided to you previously on the 19th of September. So if I can move on to the consultation on the proposed changes to the Police Service of Northern Ireland Injury and Duty Award Scheme. So to set this in context, as a result of the NIAO's report to those charged with governance concerning the Northern Ireland Prison Service accounts for 2017-18 and further audit work containing the Northern Ireland Civil Service Scheme for prison service officers, the Comptroller and Auditor General extended his review to the PSNI IOD scheme. This resulted in the NIAO report Injury and Duty Schemes for Officers in the Police Service of Northern Ireland and the Northern Ireland Prison Service, which was published on the 10th of March 2020. As you are aware, the NIAO report made 4 recommendations, primarily around the provision of greater clarity of the aims of the schemes, checks and balances to ensure the appropriate use of public funds, greater consistency, streamlining of processes, a new case handling system, offsetting payments and clearer guidance to the scheme medical practitioners. When the NIAO report was published and to address the recommendations, an Injury and Duty Steering Group was established. The membership of the steering group includes the Department of Justice Sponsor and Finance Divisions, the Northern Ireland Prison Service, Department of Finance, Northern Ireland Policing Board and the PSNI. 2 scheme-specific subgroups were also established with scheme-appropriate membership, one relating to police and one relating to the Northern Ireland Civil Service and prison officers. The steering group takes forward the overall NIO recommendations, while the scheme-specific subgroups take forward the recommendations relating to their specific work area. So you're obviously aware that the steering group and the PSNI IOD subgroup agreed to a preliminary PSNI IOD targeted consultation, which is the reason why we're here today. The purpose of the consultation was to open discussions regarding the IOD award scheme to help inform proposals to provide a sustainable, accountable and affordable IOD scheme which provides financial support given to police officers and their families should those officers be killed or injured in the line of duty. The consultation opened on the 26th of March 2024. It was due to close on the 17th of June, however, at the request of the Northern Ireland Policing Board, the consultation was extended to the 17th of July. So following consideration of the preliminary findings, we now need to finalise the analysis report before submission to the IOD steering group for their deliberations. So in summary, the consultation posed 9 questions to facilitate responses and also invited general comment. A total of 55 responses were received. 4 represented key stakeholder groups, with 2 further organisations submitting responses. The majority of the remaining respondents indicated that they were private individuals, with the vast majority of these individuals identifying either as serving or retired police officers. You're aware from the information we provided in advance of this meeting what each stakeholder group and the individuals responded. However, it can be summarised below. So the majority of stakeholder organisations were supportive of many of the proposals outlined. However, a small number expressed opposition to specific individual questions. 2 organisations expressed complete opposition to any changes to the existing IOD scheme. In the main, the majority of individual responses were wholly against any changes to the current IOD award scheme. One further issue I think I consider to be pertinent to the consultation is relation to the roles and responsibilities of each organisation. This has been raised on a number of occasions with us. As I previously advised the committee, this matter would be considered as part of the wider review. That position remains unchanged. However, I should like to advise that before any adjustments can be considered, key stakeholders must decide where responsibilities best sit. It's not just a simple matter of moving the processes from the board to the PSNI. The statutory rules are entwined with considerable complexities and interdependencies and will require extensive legal examination if change is requested, and this is not something that's going to happen overnight. So in conclusion, the consultation has received both positive and negative responses from stakeholders and individuals to each of the questions asked. The subgroup will consider these responses and their potential outcomes to maintain the IOD scheme for existing and future applicants. Until the analysis has been completed and the outcomes understood, it's difficult to determine an expected timescale for proposed changes at this stage. In addition, any proposals for changes to roles and responsibilities will need further consideration. Fully understanding how these changes may impact various areas will likely need further engagement with key stakeholders. So in terms of next steps, the IOD subgroup will examine responses to each individual question. Further work may be required from key stakeholders, including the PSNI and Policing Board, ahead of any recommendations for overall changes to the IOD award scheme. At this stage, all options remain open to any proposed changes to the IOD scheme. Responses and preliminary findings will be scrutinised prior to the finalisation of the consultation response document. Proposals on any future changes to the IOD scheme and/or associated legislation will be brought to the IOD steering group, but will likely require further consultation and ultimately ministerial approval. So finally, the committee at its meeting on the 19th of September asked for an update on correspondence it had received relating to allegations concerning the use of flawed information in the Northern Ireland Audit Office report. The Department, along with colleagues from NIAO and the Northern Ireland Policing Board, have analysed the correspondence and considered it against source information already in the public domain. I'm also aware that the NIAO replied to the committee's queries in relation to this matter. Based on our analysis, the Department is satisfied that the information contained in the individual's correspondence has no impact on the PSNI injury and duty consultation. The Department has provided the committee with a fuller response to the allocations that were made. I want to thank you for the opportunity to come before the committee today, and my colleagues and I are now willing to take any questions from members.
And thank you very much. Morris, I know you've got something around this?
Yeah, just time frame really, Chair, for implementation. And have you actually engaged with some of the correspondents who made allegations of false information to explain to them that perhaps they may be wrong or perhaps you may be wrong, just to sort of finalise that?
So the individual responses are all anonymised. We have no idea who they came from. So we can only engage with the stakeholder groups that came forward, and we have regular engagement with the likes of the Police Federation, Policing Board, all of those other bodies. In terms of the timeline, at this stage it's not possible to give you a timeline as to when changes may be affected. There's still a lot of work that has to be done. The consultation is only one part, a small part of a wider review of the whole of the scheme, and that is going to take some time to work through.
Yeah, but you are working on it.
Oh, absolutely, yes. I have a dedicated team who's working on it.
Thank you very
There's
much.
not even a ballpark.
At this stage, Chair, unfortunately not. We are, I don't want to labour this point, but we are very under-resourced, and we have a huge number of demands on the branch at the moment. We deal with all issues relating to policing, the Policing Board, the Police Ombudsman, and about 8 or 9 other arm's length bodies. So we are trying our best to progress this as best we can, but other demands sometimes are having to take precedence.
Also, a lot of subjects within it weren't clear cut. Does anybody else have anything on this before I come in? No? Okay, I just have a few things if I could work through. Part of our papers in terms of the scope of consultation, you cite that a targeted consultation exercise was conducted in accordance with statutory requirements and was extended to include several additional bodies. And then you talk about a list of recipients. So that's the PSNI, the Policing Board, the Police Federation, the Retired Police Officers Association, Injury on Duty Pensioners Association, and Sinn Féin. I mean, can I just clarify? Is this a typo? I mean, was Sinn Féin targeting this, or did Sinn Féin just respond?
Sinn Féin responded.
Right. Okay, because that wasn't entirely clear from the.
Sorry, my apologies. No, Sinn Féin wasn't the only one that was targeted.
No,
and maybe that's the wrong word to use.
No, that's fine. I think it was important to clarify that just in terms of the papers that were in front of us. The other thing is, if I could turn to page 168. Around the issue of whether or not the changes would apply going forward rather than retrospectively. Could I ask, there's been mention in the consultation responses about legal challenge where changes to be made retrospectively. Is there a risk at all of legal challenge for the people who are admitted into a new scheme, that they will be treated differently from people who were previously admitted into the scheme?
It's something that is part of our deliberations and part of our consideration at the moment. So legal advice will be taken on all of that, Chair. At the moment, I don't think I'm in a position to give you a definitive answer.
No, that's okay. I just kind of wanted to establish if it was on your radar.
Oh, it is, absolutely, yes.
That's fair enough. I suppose in terms of commentary, I would like to say it is somewhat disappointing that you've come this far and kind of considered all of the issues, and the one question that wasn't put was with whom should the scheme lie?
Yeah.
Because I think that it doesn't give a complete picture. So it is, I suppose, disappointing from our point of view, and doubtless from the policing boards, not to mention members of the scheme, that wasn't kind of included. So I suppose that's just a point to note.
In response to that, Chair, though, what I would say is that the policing board do sit on both the steering group and the IOD subgroup. So if that was an issue for them, it could have and should have been raised at those meetings.
Well, I suppose that's the one thing that I wanted to clarify with you, Lynn, because in the course of your presentation to us there, you talked about if change were to be requested.
And that's in relation to the roles and responsibilities.
Yes, and the legislative change that would be required were the scheme to be removed from the board.
Mm-hmm.
But the issue is those conversations are happening.
Mm-hmm.
There are requests that it would be taken away from the board, and that's from the board, it's from people who are involved in the scheme. So it's difficult to imagine, you're saying if change were requested.
Yeah.
But it is being requested, so
it hasn't been officially requested to us yet by the board. They are the owners of the scheme,
yes.
So they need to make a formal representation to the department to change the roles and responsibilities, because it's not just about lifting a process
yes.
and moving it from the board to the PSNI, for instance. This is about looking at the policing board's role as the scheme manager,
yes.
and the principal pension authority, I think is the title. So whilst we are aware that there is a desire for this to move, and the discussions have been ongoing for a long time, and I do accept that, until a formal request comes into us from the board asking us to do this, we're not in a position to take it any further.
Does the board, presumably there have been informal conversations, in the course of those informal conversations, has it been made clear to the board that were this to be taken forward, they must indicate formally that there's a request to do so?
Well, I believe it has been made clear to them.
Well, certainly this Hansard will make it clear.
Absolutely.
Deirdre?
I was going to ask, because my understanding is the board had requested it. It's clear that they don't have the capacity to do this, or the skill set there, and that it would be better placed, for example, within the PSNI that do. So I'm wondering if we could get something in writing just to kind of confirm what you've said there around what the process would need to be.
Okay.
And then also to clarify or not if a formal request meeting that process has happened or not. If we could get that in writing,
yes,
I would appreciate that. Yeah.
And I think one of the other things that I think it's important just to say at this stage is that the complexities around this can't be underestimated. It's not just touching on the legislation relating to IOD or ill health retirement or anything like that. We will have to do a lot of engagement with the likes of the Pensions Authority. So there are massive ramifications here that have to be considered. And that's not to say that we haven't already begun that thought process, and the board has been involved in that. But we do need something formal. I'm happy to provide that.
Thank you.
That's fair enough. Actually, just in the course of this, could I declare that I was a previous member of the policing board for a considerable period, but at no point in my time on the policing board did I sit on the committee that considered injury on duty awards. I think it's important
you
to
declare
that
as well, Chair.
Yeah, thanks, Maurice. Just a couple of other points, if I may, and then I'll turn to the issue of the individual correspondent with whom we've been dealing. One of the issues that you mention is, or one of the issues that arises in the course of the consultation, is the forwarding of officers' data. You will appreciate that, and this is something that is raised with us regularly, with serving and retired police officers, but also with serving and retired prison officers. I think in the course of this and in all of the conversations around pensions, it would be helpful for you to outline, I suppose, the considerations that you take into account whenever these are people who operate under a risk, a very considerable risk and threat. So what precautions do you take before any such information about police and prison officers is forwarded beyond your department and your area of work?
First of all, what I would say is I can't comment on the prison officer side of it. That's nothing to do with our team. We do take precautions, and I'm going to defer to both my colleagues here who can take you through that process, and we absolutely make sure that we comply with GDPR and all of those required pieces of legislation. But I'm going to pass you over to Therese and Alan, who can take you through the processes that we use.
Yes, I think actually in this here, I came new to the role and I looked at the data handling of this actually recently and have worked with ourselves and the board to revise information sharing agreement. So I think the way the information is handled is all done on a secure system within DOJ, and with the information, if it's to go out to the appellants, I believe it's recorded delivery, or we use software which has been recommended by our security officer called Box for and it gets uploaded onto there, and then it has a timeline. It'll delete automatically if it's not accessed, and only the recipient will get an email on how to access it. In terms of storing the information, I think we have now a privacy notice in place and a retention. So once we deal with our appeals and they're finished with, I think there's a retention policy of 6 months, quote me, am I right? 6 months, and then we automatically delete it off our systems.
Okay, that's fair enough. I think
so. We have
we'll
taken good precautions around that because we just wanted to be sure.
We are very conscious of the sensitivity of the information that we're dealing with. So every precaution that we can take, we do take.
I mean, and it's still a real sore point and a difficult issue for people who have left the service.
Absolutely, and I understand that completely.
And their families too.
Yeah, of course.
So thank you for that. If we've anything further on that, I will follow up with you if that's okay.
By all means, yeah.
Just if I can turn to the issues that the correspondent has raised. First of all, Lynn, at the start of your remarks, you distinguished between injury on duty and pensions. Could I just clarify, because Hansard is here with us, that the previous statutory rule that was passed around pensions and injury on duty has nothing whatsoever to do with this consultation? It is entirely separate.
Absolutely.
You're confirming that.
Absolutely.
That's great. Thank you very much. Also, within your paper dust today, you have dealt with each issue raised specifically. Are you beyond any doubt clear that everything that you have is factual and not erroneous, and that the consultation is based entirely on factual information?
Based on the information that we have, the answer to that is yes.
Okay. The other thing, could I check with you? I think it would be important for the person who raised serious concerns with us to have sight of your responses. If the committee were in agreement, and I'll put the question to the committee later on, but do we have your agreement that we can share your responses to those issues with the correspondent?
I don't think there's anything in our responses that would preclude that happening, and if that's something the committee feels would be helpful, more than happy to do that.
I think it would be, and I think, bearing in mind the gravity of this of the issues raised, I think it would be important that we're transparent in that, and that the department is transparent in that. So thank you very much. I don't think I have anything else. Does anybody else have anything? No. On that
Sorry, just before you finish, Chair, just on that issue of sharing the information with the individual, if when the individual sees what we have said, if they have any more queries or questions, by all means tell them to come directly to me, and I am more than happy to address those, and obviously we will copy any responses into the committee.
Okay, that's helpful. Thank you very much, Lynn. That's great. So, thank you. Members, I'm going to take us through them. We've got a couple of things to agree. Could I ask...
Are we happy to go?
Yes, you're.
Thank you, Chair.
Thank you very much. No, very much appreciate your coming to committee today and clarifying a number of those issues.
That much you want to stay?
Thank you.
Back anytime. Thank you, Chair.
Thank you.
Thank you.
Members, just with regard then to, first of all, the departmental paper, are you content to note?
Yes. Sorry. Yep.
Thank you. The other issue then is around the correspondent and the issues that have been raised with us, which were very serious issues, and the committee has dealt with them on a number of occasions and kind of worked our way through. To address this, and I think it's important for all concerned, could I seek your agreement to, first of all, send the departmental letter to the correspondent? Yes?
Yeah.
Yeah.
Could I seek your agreement that we send the Northern Ireland Audit Office's letter on the same subject to the correspondent? Thank you. Could I seek your agreement then also that we include Lynn's request that if there are any further queries, that those are directed to her and she will let us have sight of those? But also, could I seek your agreement, just to make sure that all of this is covered off, that we would supply the correspondent with links to the YouTube links for each meeting at which this was discussed, and also links to each Hansard at which covers off our conversations around this issue, just so that the correspondent has a complete picture as to what activity the committee has undertaken and the responses and so on, and the discussions that we have had. Are members content with that? Yep. Great.
Yep.
That's great, thank you. That's helpful. And obviously then if the correspondent has any further issues, can go directly to Lynn or correspond with the committee directly. That's great, thank you. Members, then if we can turn to agenda item 8, which is the statutory rule that we discussed earlier on in closed session. That's the Coronavirus Act 2020 extension of provisions relating to live links for courts and tribunals, number 2 order, Northern Ireland 2024. I would ask you to turn to pages 204 to 219 of your meeting pack. Just as a reminder, by way of background, this rule is going to extend the provisions in the Coronavirus Act that allow courts and statutory tribunals to receive evidence wholly or in part through the use of audio or video links until the 24th of March 2025. The committee previously noted that Coronavirus Act 2020 powers have been used to extend these provisions on a number of occasions previously. The committee therefore agreed to ask the department for its view on whether the continued use of the powers was proportionate and appropriate. Information on the department's plans to make permanent provision for the use of audio and video links was also requested. The department had stated that the Minister was satisfied there remains a clear role for the continued use of the provisions to tackle the backlog of cases that accrued during and since the pandemic, and it may take until 2028 to clear without extra resources. The department also advised of the Minister's intention to include provisions to cater for the wider use of live links as part of the Northern Ireland Courts and Tribunal Service digital modernisation programme within the department's first bill, and that the reliance on the powers in the 2020 Act is therefore expected to be an interim arrangement. Based on that information, the committee agreed to recommend that the previous rules be approved by the Assembly, and we're now aware that the department plans on bringing such provisions by way of amendment at consideration stage. The examiner of statutory rules has not yet reported on the rule, but the committee was briefed by her in closed session earlier, as most of you will be aware. Do members have any comments, queries, or are you content with the statutory rule?
Content.
Okay, if you're content, then I'm going to put the question. So the question is that the Committee for Justice considered SR 2024-173, the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, number 2 order, Northern Ireland 2024, and subject to the Examiner of Statutory Rules report, recommends it be approved by the Assembly. Are members agreed?
Agreed.
Thank you. Members, obviously then I will reflect the committee's views in the plenary debate on the statutory rule, which has been scheduled for the 4th of November. Agenda item 9 is another statutory rule. It's SR 2024-177, the Rules of the Court of Judicature, Northern Ireland Amendment 2024, and that's at pages 220 to 241 of your pack. This statutory rule will amend the rules of the Court of Judicature, Northern Ireland 1980, to provide for a time limit in a civil case so that an application for leave to appeal to the Supreme Court shall be made within 28 days of the decision or the order in respect of which leave is sought. At our meeting of the 27th of June 2024, we agreed that we were content with the proposal for the statutory rule. Also at that meeting, the committee agreed to write to the Department of Justice and advised that its view was that the change would be implemented that the change that would be implemented by the statutory rule would need to be publicised as widely as possible among the legal profession, and to ask what plans the department had for doing so. The department advised that, subject to the rule being made, in due course, which makes me a wee bit anxious, it would correspond with the Attorney General's Office, the Law Society, the Bar of Northern Ireland, the Departmental Solicitor's Office and the Crown Solicitor's Office to advise of the new time limit and when it is due to come into operation, asking that they disseminate the information as appropriate. Honestly, my preference would have been that it would have been done in advance, but they've said they're going to do it, so we'll take it. The Examiner of Statutory Rules has raised no concern regarding the technical aspects of the statutory rule in her report that was published on the 11th of October this year. The Department has confirmed that there have been no changes to the policy content since the proposal was considered by the committee. Do members have any comments, or are you content with the statutory rule? Thank you. Then I'm going to put the question. That the Committee for Justice considered SR 2024-177, the Rules of the Court of Judicature in Northern Ireland, Amendment 2024, and has no objection to the rule. Members agreed?
Agreed.
Thank you. Agenda item 10 is the Planning Appeals Commission fees and a consultation on amendments. Could I ask you to turn to pages 243 to 292 of your meeting pack for the relevant papers? The Department has provided a written paper advising that it plans to consult on draft regulations that would increase the fees payable for applications and appeals to the Planning Appeals Commission. I'm asking you to note the information provided unless there's any further information or clarification required at this stage, and doubtless then we'll see the results of the consultation.
Noted.
Yeah. What's also known as the 19% increase, which seems to be quite a lot in one go, although the department has specified that DFI increased by 12% in one go.
Just on that, Chair, just appreciate that is quite a significant increase, and I think through the process it'll come clear that, you know, the service and performance has to improve from, you know, I think the sector that are involved with the PAC, will certainly come through, I would imagine, through the process. So I think it's an interesting one to keep an eye on.
I think we will. Usually in these circumstances, we're sent details of the consultation responses, so it'll be interesting to see at that stage, and then we can take up any of those issues with the department, Stephen. So we'll leave that in your capable hands when the time comes. So agenda item 11 is the Forward Work Programme. An updated Forward Work Programme is at pages 294 to 303 of the pack, and a proposed Department of Justice Forward Work Programme is at page 304 of the pack. Are members content to note, or do you wish to raise any issues? Thank you. Item 12 is correspondence. You'll see there's a correspondence memo and 24 items of correspondence at pages 305 to 782 of the meeting pack. I'm going to draw your attention to a number of the items, as I usually do, and then I'll open the floor so that you have an opportunity to comment on any other items of correspondence in which you have a particular interest. So the first thing I have is item 12.1, which is correspondence from the Minister at pages 312 and 13 of the Minister of the meeting pack. This is a notification of the commencement of section 28.1 and section 28.3 of the Investigatory Powers Amendment Act 2024. Are members content to note this item and consider any potential follow-up after the public consultation on a draft code of practice on the new legislation that we're told will include information on section 28.1 and section 28.3? Was everybody clear from that letter what the implications were and what the practical implementation was? I wasn't sure that I was. I wasn't clear from that exactly how it was going to work. But maybe it'll become clear in due course if everybody else understood.
More info comes, yeah. We'll get that when more info comes forward. We will not know.
I hope, because I struggled with that. I must say, I just want to be clear how it's going to work in practice. You know what it's going to mean.
Could we ask for that, or even a written or whatever update? Just
Chair,
to lay out in practical steps what way this is going to work.
If members are content, I think that'll be helpful.
Chair, written or oral briefing?
Written, probably.
Whatever's easier way to get it across.
I think written at this stage because we've
Yeah.
got quite a lot on our plates at the
Going
moment.
on. Yep. Okay.
Yeah. Item 12.8 then is correspondence from the Director General of the Prison Service, which is at page 406 of the pack. And she thanks committee members for visiting Magabry. It was a really useful visit. I'd like to ask members to note, and actually it had been my intention that we would actually write to the Director, so that's Beverly Wall, Dave Kennedy, and also Tracy McGrath, the Governor of Magabry, to thank them and their prison officer team for a really informative visit, and also those from Belfast Met. So if we could do that, that would be great. Members agreed?
Agreed.
Thank you. Item 12.15 is correspondence from the Commissioner Designate for Victims of Crime at pages 644 to 645 of the pack, in which she raises concerns that the proposed extension to the committee stage of the Justice Bill may have an impact on the introduction and passing of legislation later in the mandate. The options are that we note this and discuss further with the Commissioner when she's in front of us in a couple of weeks' time. But I must say, my preference would be that we do formally reply to the Commissioner. I mean, she wrote to us, and I think that we should write back. Deirdre?
Yeah, I was a bit surprised to get this letter. And in terms of just the approach from the Commissioner, just to say in terms of extending the committee stage and the negative impact that would have. And I mean, we haven't once said that that's going to have a negative impact on other legislation. In fact, we've been very acutely aware that there's the potential of 3 bills. And our concern is just to give the right time for scrutiny. So I don't know if the Commissioner in ways is overstepping her remit. And it would just be, and I know in some of the engagements that actually she would have preferred her pieces of legislation to be contained in the first bill. Mm-hmm. So I think, I mean, we can explore this with her but I think maybe just to give her a heads up then in advance of her coming to committee in November, she's due in anyway. Yeah, that we do formally write back. Just in terms of, you know, we've always said as a committee that we will do the bill as quickly as we can. This is our one time though, obviously, to do an extension. And we want to make sure we get it right on the back of a High Court judgment which ruled part of previous legislation, not law. And I think that's serious, and we obviously need to take that into account. So I'm just wondering, is this the norm for the Commissioner to write in this way? But maybe that's something that we can put to her as well when she's in front of us.
Well, I think, first of all, in terms of whether or not it's the norm, I suppose the officials could tell us now whether or not it's usual.
Chair, something probably take advice on and come back.
Right, I guess, Chair, the Commissioner is a Commissioner designate, and the intention, as I understand it, and we've been told, is that to become the Commissioner requires legislation, and it's currently at the tail end of the legislative process. Mm-hmm. So undoubtedly there will be concerns at the length of time that we may ultimately run out of time, or that we will end up in a not dissimilar situation where legislation starts to bunch up at the end of this mandate.
Deirdre?
I think it doesn't add, in terms of balance to that then, is there a guarantee the bill's going to come? That's not included in the letter. It's just in terms of the committee, or taking our time as a scrutiny committee, which is what we're here to do. But she doesn't allude to the fact that maybe the bill won't come, or it's going to come late, or, you know, there's going to be sections of it that aren't going to come until later, the way there is with this bill. So I suppose it's hard to know her thinking behind this until we...
It is, and doubtless we'll have a conversation with her. But I think that there are other aspects too. I was a bit taken aback at the letter and the tenor of the letter. The committee makes a decision based on advice that it is given. With regard to this bill, there are numerous unknowns. And thus far, a number of items emanating from the department have been late, including the designated powers memorandum, which should have been with us prior to second stage. So, you know, the other aspect of this too is I appreciate that the Commissioner's position may be included in the third bill, but does that not then raise issues of conflict of interest in terms of such a letter? I suppose, well, that's a matter for the Commissioner's judgment. However, I think it's important that everybody understands, because there's a lot of public commentary around this, I think it's important that everybody understands that the committee has not been shy, nor will it hold back in terms of putting its shoulder to the wheel and getting the work done. I think the rationale behind the extension of the committee stage has been borne out. It's been all there for the public to see, and it will be further elaborated on at the debate, which is scheduled for a couple of weeks' time. But I think that it would be helpful if the committee were to respond to the Commissioner to provide her reassurances along the lines of the issues that we have considered in terms of our conversations that we've had previously with regard to the timeframes, the things that we've borne in mind, and also the issue that Deirdre has raised there, because I think it's important that the Commissioner understands everything that we've taken into account thus far and why the decision was made by the committee for the extent of the extension. And no doubt it'll all be played out on the floor of the House anyway, but I think it's important that we respond to the Commissioner. She's taken the time to write. So are members content with that approach?
Yep.
Thank you. I also want to refer members to item 1217, which is a paper from the Chairperson's Liaison Group, and the only reason that I'm referring to this is there's a paper tabled to the Chairperson's Liaison Group with regard to post-legislative scrutiny. And I want to congratulate the Committee for Justice team, because within that paper they are held up as examples and of their tracking and of the systems that they've put in place to check. And I think it's right that as committee members we would pay tribute to our committee team for the work that they put in. Whenever the Assembly was down, they used the opportunity and used it very well and very wisely, and I would like to commend them for setting an example to the rest of the Assembly, so well done.
Is that a raise? Is that a pay raise?
I'm not sure that's within our gift. Morris, Justin, I see you have your hand up there. Do you want to come in?
Sure, that was applause only.
Oh, it was applause. Oh, very good. There you are. Round of applause. Very good. Thank you. So then at item 1219, there's correspondence in from the Law Society, which is page 725 of the pack, and that's a request to informally and formally brief the Committee on Criminal Legal Aid Reviews initiated by the Department of Justice. You'll see from that correspondence they want to informally brief us with regard to the comments that were made by the Department when we had our conversation around the budget. That was a couple of weeks ago, and then they want to formally come and give evidence on the Justice Bill. So can we note this item, and then can I seek your views as to what way you want to deal with the Law Society regarding this review of this Burgess review? Ciara?
It's in line with 1210 from the department in their response to the Criminal Bar Association Industrial Action, and then likewise the Criminal Bar Association 12.25, their letter in relation to the announcement of the withdrawal of their services. And then likewise we had a meeting with the Law Society and the Bar Association at the All Party Group this week, and I suppose how I felt personally that and there was a number of presentations, and Extern was there as well. It seems to be in a dire situation where they have many years of working at 130, 140% capacity, where they have real term cuts, where there has been no increase in the fees in many years. I'm not saying it's something that's happened recently. This is over a long period of time. Yeah. And then likewise the payment delays, where it's looking like it could run in the 6 months now, not even 3 or 4 months. So based on all those circumstances, and obviously the great engagement that they did have with His Honour Tom Burgess for this review, I think there was an expectation or hope that this review could be published as soon as possible with the recommendations. Obviously there's other work that needs to be done through the department to follow up through actions, but at least you see the recommendations, because that's what happened elsewhere in GB when there was similar reports done. They were published quite immediately, so it's that concern. So I'm conscious of, and then the department has announced that it will happen in the coming weeks. So we have a situation
What
where
will happen in the publication?
a statement, a ministerial statement, will happen in the Assembly. I would assume, but maybe I would assume that a statement on the actual Burgess report. That's what the assumption I'm making. So there's a time delay here between the withdrawal of a service, and it's over at 300. And I wouldn't know what the scale impact that will have on the courts, but it's imminent, and it's on the 4th of November.
Mhm.
And between times, dated on the 18th, which is last week, we have the department telling us there will be an announcement in the coming weeks. So
what do you want to do?
I would just be keen between if the department could engage, at least as a minimum, with maybe the Bar Association and the Law Society with a date and time. I would assume there must be some schedule now when the Minister will be coming. It's in the coming weeks, so it's all quite imminent, and if there could be some engagement, so we could prevent any withdrawal from any service.
I think that there's a couple of things. So there's the issue around legal aid generally, and then the Bar Council strike. There's the issue about the publication of the report. And then there's the Law Society, which has separate issues. So one of those issues is legal aid. The other one is giving formal evidence on the bill. So let's take the Law Society first, because that's the one that's in front of us. They have requested an informal meeting with regard to the comments around legal aid that transpired between the department and us whenever the department gave us its financial briefing 2 weeks ago. First point is, are you content to have that informal meeting with the Law Society or otherwise?
Was that pertaining, sorry, to
the legislation?
No.
No,
It was
the Burgess
budget
report.
more broadly, was it?
Yes, it was, and so in the course of our conversation with the department, I mean, certainly I had raised issues about legal aid and the impact on that with regard to access to justice. Do you remember we went through some of those issues and the impact in city and rural? Nobody's coming through. All of those issues were raised, and then the department, the Permanent Secretary responded to that. In light of the issues that arose there and the responses, you'll see in the pack at, what page is it at? Could somebody give me the page? 725, is it?
725.
At page 725, you'll see then that there's an email in from the Law Society seeking to have an informal meeting around those comments and the issues as they see them. So, first question is, do you want to go ahead with that?
So we're not better waiting to get the Burgess report. We will have a debate and a discussion on that. It will be shared with all of the appropriate stakeholders, and we will all be in an informed place. An informal discussion will be just talking into a vacuum at this point in time, because none of us know what's in the Burgess report.
Well, that's the second issue. There may be a statement on the Burgess report forthcoming, but we have no notion about a publication date.
No.
Deirdre?
I think there's a number of different issues, and obviously they can easily all be conflated
Yes.
into one, and it's not. There's obviously, as you say, separate issues over long periods of time that have now just built a head of steam. So it's just trying to think of a logical way that we can approach it. I mean, legally it is a building issue, there's no doubt about that. It's a demand-led service, our budgets are under pressure. And I suppose the big concern for me is that access to justice, because we know from talking to people on the ground, there's big difficulties in trying to get solicitors now who are doing legal aid work, let alone a barrister. And I'm really concerned about the impact that has in people getting proper representation. So I don't know if it's through what process we can use in this committee then to do a dedicated session that looks at all of these issues, or do we take it over a period of time? So I think on the one hand it would be good to potentially write to the Minister and ask when the statement is going to be given, ask for clarity on when the review is going to be published. Is that going to be included in the statement or not? So I think to ask that, because obviously, as Ciara said, I mean, the industrial election is actually on the day that we're back in after recess. So I think if we can get clarity over the next week on that, and then do we look at the whole issue around obviously the criminal legal aid and the issues that pertain to that, And you're right, there's different issues for the Law Society as there is for the bar, and there may be different issues for people who are trying to access legal aid on the ground. So how do we engage all of them? And then there's the civil end of things that hasn't had any review as such. How do we engage
that would be
with that?
in-house, but the criminal legal aid was...
So how we engage
commissioned.
with that, and then the other bit is obviously the bill and the taxation, you know, which should come then in terms of the evidence sessions and all of that. So it's maybe
I
trying
think we
to
should
the best way to manage.
I think we should hold the evidence.
Yes.
For the evidence
No, I agree.
sessions.
I agree with that.
Whatever goes on with legal aid, that's fine. But in terms of the issues that pertain to the bill, I think that we should deal with those as we're making our way through the bill.
Yes.
Yes.
Yep.
So
How
then
we
that
just
leaves us
manage
with-
this in
yeah.
chunks, I suppose,
Yeah.
and how we put that into your work programme then going forward.
The reality, Chair, is we know what the no-ones are, and the no-ones are that there is insufficient funding. We know that the department is managing it by making delays in payments, and one assumes that the Burgess report is going to deal with that and produce presumably recommendations to make changes. Some of those changes will be able to be done just by administrative changes, and then we have the big piece about the taxing master, which is in the bill. So until I think at this point in time to debate this bit of it, the only discussion we can have, meaningful discussion we'll be able to have, will be with once the Burgess review is available. But the day after the Burgess review is published, it's not going to provide a penny more for legal aid. It's going to perhaps give a roadmap towards how it will be dealt with going forward, but it's not going to provide a penny more.
The issue for the bar is, in accordance with their correspondence, they are looking for immediate movement, otherwise they're going to strike. I don't know from
But
where
if
it's
no more
going to
money,
come.
do they not understand?
I'm not clear from where it's going to come. But you can understand, I mean, we have heard ourselves that the department uses the legal aid budget as a budget management tool, and uses the delays in payment as a budgetary management tool, and the department is never given sufficient monies to cover the legal aid budget. It always has to rely on monitoring rounds. So it's a very difficult circle to square, this one.
Very difficult.
But I think it's important that everybody concerned knows that we're cognizant of the issues, and for the firms themselves, for the barristers themselves, but for the citizenry in terms of access to justice and the long-term issues that this brings. So, right, so there's a proposal on the floor that we write to the department with regard to when it's going to be published, and what was your second part of that, Deirdre?
Just in terms of the ministerial statement.
Ministerial statement.
So clarity on what that is and when. Is it going to be that week after recess, which will coincide with the action? And then I also think then is there a proposal in terms of how we approach these issues as a committee?
Mhm.
So just to coordinate a wee bit of, I know it'll be adding to our work programme, but I suppose, I mean, the Law Society have written in, and I'd be happy to meet them, but as part of maybe that work programme where it makes sense. And then you're including the bar, but separately, because they're different issues that they have. And as you say, if there's others that we feel we need to be speaking to.
It's not a small issue.
No, it's not.
If there are conversations ongoing, I think that the committee should be familiar with the report.
Yeah.
You know.
Let's get the report.
So
But
get
again,
clarity
the
and
onus
then
is
we'll-
on the department not to hold the report. You know, the department could still be working on its response to the report, having published it.
Yeah.
To my mind. So the issue here is, get it published, and then let's get the conversations underway. But we're all cognizant. I mean, the department is cognizant of the problems that there are. I don't think it's an ideal situation for them either.
Right.
Okay, so are we okay with that?
Yes.
Yes. Okay, thank you. Right, the next issue then is item 1222, which is correspondence from the President of the United Kingdom Supreme Court, and that's at page 778 of the pack, and that's a request to meet me and the Deputy Chairperson on the 13th of November. Are members content to note this item, and are you content for the Deputy Chairperson and I to meet the delegation?
Agreed, yep.
Thank you. Can I ask you to turn your attention to the tabled pack? Correspondence number 1227, which is pages 5 to 62 of the pack. The Department has responded to the Committee's request for additional information in relation to the Justice Bill, and these include a European Convention on Human Rights compliance table, a summary of responses to the consultation on the use of live links for police detention interviews, and a delegated powers memorandum. Could I ask you first of all to note these items?
Noted.
Does anybody have anything they want to raise on those? Then could I seek your approval that the delegated powers memorandum is sent on to the examiner of statutory rules, because she was supposed to have had it before second stage, so it's important that, that's considerably delayed, so it's important that she would have that in order that she can commence her work. Members agreed?
Yep, agreed.
Thank you. Can I also ask your agreement to forward the compliance table to the Northern Ireland Human Rights Commission? Okay. Should we also send that to the Assembly Legal Services? That's great. Do we need to agree that, or is that just a given?
Yeah, I can do it to formalise. Yeah.
So members agreed we send it to Assembly Legal
Agreed,
Services too. Thank you. Are members content to note the other items of correspondence as set out in the memo, or do you have any comments you wish to make on them?
Noted.
No. Right, just a couple of other items then. Agenda item 13 is chairperson's business. You'll note that there's a concurrent meeting of this committee and the Committee for Health, and that's been scheduled for next Thursday at 2 p.m. in the Senate chamber. So that is a standard meeting, but it's a joint meeting with the Committee for Health, where we're going to receive evidence on right person, right care. Now this ties into one of our strategic priorities, which is the impact of mental health on the criminal justice system, and the extent to which pressures are being picked up by the Justice Department and family on behalf of the Department of Health. So could members indicate as quickly as possible, please, whether they intend to be there in person or online?
I'll be there in person.
Thank you.
Next Thursday?
Next Thursday.
Thursday.
Sorry, not next Thursday, the 7th.
Yes, in person. Sorry, yes. I beg.
That should be all right.
That's good. I think it's
Be in fancy
important.
Is that a
dress next
Wednesday?
Thursday.
Oh, it's a Thursday?
You'll be in fancy dress next
Yeah,
Thursday.
next Thursday on your own.
Halloween.
But so that's the 7th. But just
The only time of the year I'm not in fancy dress.
dapper. So that's great. But I mean, I really would encourage members to be at that. It's important that there's a reasonable showing from this committee, Deirdre.
Yeah, no, you're right, and it's good the officials, because obviously, as I said, there was another death in custody. I know when the Minister responded to a question I asked the other day around addiction and substance use issues and stuff, and obviously when the Chief Constable was here with us, he highlighted that in terms of the calls, that they're now taken at A&E. You're even seeing that this week. So I think it's definitely timely that we're doing this meeting, and it's actually good that we are starting across departments to kind of maybe align some of the work, particularly around even transformation bids and stuff going forward. It was a question I asked in finance the other day around how many of those bids have been cross-departmental, because obviously they get a 5% weighting if they are around breaking down the silos. So I think this gives us a real good opportunity, as you say, to get into that in a bit more depth.
Yeah.
Also,
And
Chair,
then the visit.
sorry, go ahead.
No, sorry, we're doing the visit, obviously the Inverary House and stuff, so all that kind of
it all
aligns
ties in.
too.
Yep. Mark?
As you say, there's an awful lot of people in prison who shouldn't be there because the judiciary feel that if they send them to prison, they will get the help they need.
They don't.
And, once they leave prison, it's back to square one. They don't get any follow-up help.
And
It's
also,
a big issue.
prison service officers are not trained to deal with
Yeah.
the psychological issues and the mental illness issues that some people in custody are facing. And it's not the best place
Okay.
for them, but I think it'll be really helpful to hear from the health side of things and the policing side of things. So that's great, thank you. Almost finally, members, could I refer you to correspondence received from the Private Secretary to the Minister of Justice, and that's at page 3 of the pack. And it's a request from the Minister to meet the chairperson and the deputy chairperson of the committee to discuss collaborative working, with particular reference to the delivery of the legislative programme for the rest of the mandate. There's no question, if you've read the email, I think the issue at stake here is the extension of the committee stage. So are members content to note this item? Do you have any issues you want to raise at that, or do you want us to raise on your behalf? Are you content that the deputy chairperson and I would attend, first of all? Yes.
enough. Yeah.
Are there any particular issues you want us to raise? I mean, that's what the conversation, it's going to be around the extension of the committee stage. I'm acutely conscious at this stage that the committee made the decision. The deputy chairperson, I have no authority to change the decision. Only the committee has the authority to change the decision. So we'll see what comes out of the meeting. As far as we're concerned, we are determined to progress this as constructively and collaboratively as possible. There's nothing that precludes us from dealing with more than one bill at a time, and we're certainly content to put our shoulders to the wheel, and that'll be the message that I'll be carrying on behalf of the committee if you're content to the Minister to give her some reassurance.
Also, Chair, if we can get the bill through sooner than March 27, we will endeavour to do so.
Yeah, I mean, it's a limit, not a target.
I was just going to say I echo that point because we've said that anyway consistently that it's not the deadline that we're going to work to, but just if there is anything coming out of the meeting, obviously we'll endeavour, because I'm conscious that's the bill's going to be debated depending on when we're meeting. The extension's going to be debated, so we'll just even give an email update to members then, or Caroline can do that, just the outcome of the meeting or whatever. Yeah.
Agenda item 14 is any other business. Does anybody have any other business? No. So the date, time, place of the next meeting. So next week is recess. Yay. And the following meeting then will be a concurrent meeting with the Committee for Health on Thursday the 7th of November at 2 p.m. in the Senate chamber. The meeting after that will be the one at which the Minister is coming then to give evidence on the bill to the committee. All right, members.
Yeah,
thank you very much. Meeting adjourned.
Thank you.
Joint
Thursday
afternoon.
Yes.
Oh, that's good. I thought it was
No, it's
Thursday morning.